It's usually all well-intentioned. You put your adult child on the title of your house, maybe even on your bank account. There have been some changes to the tax law here in San Diego County, really in the state of California. And we're going to dive into that today, how to protect your assets, how to protect your home, how to protect your bank account, and how to make sure that when you do pass on, that your children or any of your beneficiaries are not left in a financial mess. Let's dive into it. If you have been in San Diego any length of time, you have heard of the lawyer in blue jeans. Jeff Isaac, now his son Justin Isaac, is in charge of the firm. First of all, Justin, so glad to talk to you. Tell us a little bit about what you guys do at Lawyer Blue Jeans.
Well, thank you for having me on. I appreciate it. We are an estate planning firm. We are here to help you pass along your assets to your loved ones without going through the courts, without getting the government involved. That's all we do. That's all we focus on. We don't have our hands in a lot of different fields of law. It's just estate planning.
And that's so important because people do not realize how important this is until you realize you did everything wrong.
Well, usually you're not the ones who realize how bad it is or what you've done. It's your kids or your loved ones, because if you don't have documents in place, essentially your assets go through the courts. And that's where it really takes a bad turn. Someone asked me once, what's the whole probate process like? And I told them, well, it's like going to the DMV for 2 years straight. So if you like going to the DMV, you're gonna love going through probate. And the kids are really the ones, or the kids or your family members, whomever it might be, are the ones who have to pick up the pieces and go through the whole court process, which on average does take about 2 years here in San Diego. And there's a lot of reasons for that, but mainly it's because we only have 3 judges in all of San Diego County for probate. And it's just it's a very slow and arduous process. So it's to be avoided as much as you can at any time.
Yeah, I was going to say, it sounds pretty horrendous. And that's why we're having you on today to talk about this. So I think a lot of people falsely assume that if your parent passes away, you as the child, whether you're a minor or not, or an adult, you automatically inherit what they had. True or false?
Typical lawyer answer, kind of, but not really. Automatic is, I guess, a little subjective, because you might inherit what they have left behind. But what does that mean? How long does it take? Well, that's the whole court process. So if you don't have a trust, that means you could be in court waiting for the government to give you permission to take control of those assets for a couple of years. Whereas if you have a living trust, a revocable trust, an inter vivos trust, it's all the same thing, essentially, just different terms. That essentially transfers over to your kids, to the people you choose, in lightning speed compared to the court, and also without any government or court intervention, which is why it's so nice. It's a private document as well, and you get to choose who gets what. Whereas if you go to court and you have no will, you have no trust, the court will decide who gets your stuff. Even if you're estranged from family members, or if you disinherited your kids, just, in theory, not on paper, it's going to go to whatever the court says and not what you want necessarily.
What's the difference between a will and a trust?
A trust does not go through probate. A will does. And it was part of the vernacular. It's part of our kind of our society that, oh, I got to update my will. I have a will. And that's what used to be the governing set of documents upon passing. But it's just not the case anymore, especially in California. Because if you have a will, you go through probate. That's it, pure and simple. There's no ways around that. If you have a will, you go through probate. If you have a trust, you don't go through probate unless something was screwed up or someone sues or something like that, which we can't avoid people suing. This is America. We love a lawsuit here in America.
Okay, good to know. And I'm glad you spelled that out, because a lot of people still have their will that they put together decades and decades ago and think that they're covered. And as you mentioned, Justin, clearly they're not. Okay, so I want to talk to you about what happens to your property when you put it in a trust and clearly name out the beneficiaries of that trust. So let's just talk about that for a moment.
Yeah, so essentially, if you have one property and you have two kids and you want it to go to them when you pass away, they just receive that property equally. If one of them wants to buy out the other person, they can do so. It's kind of up to them at that point. It's all pretty seamless because there are rules against, okay, so a couple of things. One, your taxes don't go up by transferring a property into your trust, okay? So your property taxes, that is. Two, your mortgage cannot be accelerated for transferring into a trust as well. So if you owe $500,000 on the property, the mortgage company can't come in and say, hey, look, you made a transfer of that property. We want all our money now. And they can do that for things like an LLC, which we can talk about later on. But it all passes along to your kids. Usually they're able to assume your mortgage as well, as opposed to re-qualifying with these horrible rates that we're at today. And so that's another bonus or benefit as well. And on top of that, your primary residence can transfer to your kids and they can maintain your property tax basis that you've had. So if you've had Prop 13, they can keep that as long as they fit within the parameters that have now been kind of changed by Prop 19 from 2018, 2017, I think.
Okay, and I really want to focus on that because you and I have talked off camera that when my grandfather recently passed away, he did have his property in a trust. My mom took it out of that trust and put it in her own trust. Mm-hmm. Then she was reassessed on property taxes, which she didn't know was going to happen. But that's what you were just talking about with Prop 19.
Yeah, so there's restrictions when it comes to transfer of property. So the decedent, it had to be their primary residence. The person inheriting it has to be a child of the decedent, and it has to be taken as their primary residence. And there's other metrics too with the value from the whatever the county assessor has for the value on their rolls, plus $1 million compared to the market value. So it gets a little complicated, but this is something that the county has been working through some issues on, and we've been dealing with it for a while too. And Heather, like I said, I think that's something I can help with because it shouldn't have been reassessed if everything was done correctly and the paperwork was turned in a timely manner. But the county has been reassessing every property for the most part, even if it does qualify for the parent-to-child exclusion.
So how could this have been avoided then? And I'm just asking that on behalf of somebody else who might be listening to this interview.
Yeah.
Should the property never be taken out of the original trust?
It has to be. It can't be kept in the original trust. So the paperwork just has to be done the right way. So see an attorney who knows what they're doing. Unfortunately, we've had a crash course in how to make sure that this is done right. We've had probably 100 plus clients who've had issues that we've helped them with as a part of our services too. So if anyone wants to check with me and see if we can help, depending on the situation, there's a good chance that we'll be able to, because we know the ins and outs of this rule ad nauseum. So we're definitely up to speed on all the rules and little niches of the law.
Okay, that's good to know, because so if you unfortunately have to go through that where you have a parent or a grandparent who passes away, that you are in their trust as a beneficiary. Pause everything you're doing, probably reach out to you, Justin, and learn about this before you go and make a mistake.
Yeah, definitely filing the paperwork the wrong way will be a setback. We've had that before too, where someone filed the paperwork or they thought they did, and they thought they were qualified and they weren't. Then we've also had people who were qualified and they had it rescinded by the city as well, or by the county. And that took a while for us to fix, about 6 months or so. And there's a high likelihood that, if you do the paperwork and you get it wrong, they're going to ask you to pay the higher taxes until we fix it, until they get it right. And then they'll try and refund the money afterwards. So it's a bit of a pain, but it's still something that is worth it if you can save that property tax value. Okay,
so good to know. This is so helpful because so much of this has changed just in the last couple of years.
Yeah.
Almost silently changed until you realize that you're in an uphill battle.
Yeah, Prop 19, there's a lot of whispering about Prop 19 and the wording of it and how people really, really don't like it. There's a lot of advocacy groups out there who are trying to get it overturned still. I don't know if that's going to be possible just because the state has seen so much money come in as a result of it, of this increase in property tax. And then also what would they do? Would they refund the people who didn't, qualify for the parent-to-child? I've had people had to sell the house of their parents in order to pay for the property tax because they didn't do the parent-to-child exclusion correctly. Their property tax went from, I think it was $1,900 a year to $22,000 a year.
Oh, yeah.
And they couldn't afford it, so they just had to sell their family home. So there's a lot of upset people about this, but I don't know if we can get it to go anywhere because there's a lot of money coming in as a result of it as well.
What else should people know, Justin, about putting their property into their trust and naming beneficiaries? What other advice do you want people to know?
Well, I think that a lot of people try and take the easy way out by adding a beneficiary on, the property. That's a possibility. It's not a great idea. Every title person will tell you that as well, too, just because it's going to be almost impossible to get title insurance for up to 5 years, meaning you can't sell the house. The kids can't. On top of that, people try and put their kids on the house or maybe on the bank account. And if they pass away, then it just goes to them. Well, that's not a great idea as well, too, because if one of your kids gets sued and they're on your house and this lawsuit, they go after everything that your children own. And so they can take your house. They could take everything in your bank account, even though you weren't even a party to the lawsuit or involved in an accident or something like that. And people try and take that easy way out, and it can lead to some very disastrous results. And that's why having a trust, having everything in place for all types of situations that may come up, having a backup plan to everything, having it all laid out, that's really the best way to go, in my opinion, to make sure you're protecting your family.
Okay, I want to back up on some of that because I think what
Sure.
you said was really important. Oftentimes people will put their adult children, sometimes even their minor children, on their bank account,
Yeah.
on their deed of their house.
Yeah.
I have my terminology correct here. Thinking that, okay, then it's just yours. If something happens to me, this now becomes yours. It seems well-intentioned, but you brought up something really important. Let's say that adult child causes a car accident that injures somebody. That person turns around and sues. Well, because your adult child is on your house and on your bank account, now your stuff is sort of collateral in all this. Do I have that right?
That's absolutely correct, because they are a part owner of the account or the house. And that means that is a possession that they have. So if it's something that's in your name, if it's something that you own, and say your insurance doesn't cover you in this lawsuit, or you did something really wrong, well, they're going to come after you for everything you have. And even though that's not really yours, hey, you're on title, they're going to go after it. They'll get it too. Every lawyer will go after whatever they can to cover expenses and costs and, their own fees, especially. On top of that as well, not to add another extra layer here, but if you do add one of your kids onto your property, that capital gains exemption that you were to receive by transferring it through your trust goes away partially. So I'll give you an example. Say if you bought a house for $100,000, and I'm not a CPA, and talk to your CPA if you want more clarification, but if you bought a house for $100,000 and it's worth now $1 million, well, you have this capital gains exposure where if you were to sell the house during your lifetime, you'd have to pay capital gains on that $900,000. Well, if you transfer half of that house to your kids by adding them on the deed, well, they now are on the hook for the capital gains exposure when they sell the house. If you transfer it to them through inheritance, like a trust, there's no capital gains. They now take the house at the $1 million valuation and they can sell it right away with zero capital gains.
Wow.
But if they had not taken it through inheritance like a trust and you just added them onto the property, their capital gains exposure could be pretty significant, usually around 20%, which my kind of math, it would be about 180 grand that could be owed to Uncle Sam just for selling the property. So it's not a great idea to do something like that. And it's, again, even better to have it go through a trust because then you get to eliminate that capital gain exposure.
Okay, well, these tips are so helpful because I know putting together a trust is timely and it really can be expensive. It's, there's certainly an expense that are attached to it, but what it could save you as far as the headache down the line and the tax liability, I mean, I think people really need to think through this.
Yeah, absolutely. There is some short-term cost for a trust, and it's not as bad as most people think. But again, in comparison to capital gains losses or probate fees, right? Your probate fees are based on the gross value of your estate. So if you have $1 million property and you owe $1 million on that property, well, you would think that your estate is zero, right? You have zero equity, but the probate fees are going to be based on $1 million. And so the fees are a lot higher than you would think. And the attorney who works on your probate gets paid before your kids, which is another bizarre kind of backwards thing as well too, which is just all the more reason why you don't want to go through probate. It is a terrible process.
Yeah, it sounds like it. Hey, Justin, how do people get a hold of you if they have some more questions about this before, they decide to put an adult child on their bank account or on their house? How do they get a hold of you?
So our website is lawyerinbluejeans.com, or you can email me, justin@lawyerinbluejeans.com. We have seminars about living trust all the time. We have another one coming up at the end of January here. A lot of good information on our website too. But if you feel like just emailing me a question, most of my morning is just responding to emails from clients. I'm used to it. And I feel like I can do a pretty good job of explaining some very complex, issues in law. But feel free to reach out. Yeah, lawyerinbluejeans.com or give us a call, 619-683-2545.
All right, Justin, thank you so much. We appreciate your time.
All right. Thanks, Heather.